Welcome to the Community Forum segment of the Housing Gap podcast. I am your host, Florice Neville-Ewell, and today I have brought together a group of experienced lawyers to discuss DC tenants' eviction rights. This community forum is long overdue. We know that evictions under normal circumstances negatively impact families in many ways. Family instability, disruption and displacement, homelessness, increased shelter costs, increased policing, incarceration, prosecution and court costs, costs related to encampment, cleanup, and sanitation, disruption to their children's education, loss of employment and/or difficulty finding employment, increased risk of physical and mental health issues, increased healthcare costs related to the same, increased risk of children entering foster care and/or experiencing abuse and neglect. These are just a few of the many ways in which evictions negatively impact communities. Indeed, even before the pandemic, from 2014 to 2018, it was clear that 1 out of every 9 renter households in DC was impacted by the eviction process. 1 in 40 of those households was actually evicted. Although there is a moratorium on evictions, the pandemic, of course, has exacerbated this problem. As a result, the question on the table before these wonderful panelists this evening is what will happen after the moratorium. Experts predict that nationally, 32.3% of the population is at risk. In DC alone, 31.7% of the population will be at risk of eviction. These statistics explain why the Housing Gap podcast is sponsoring this forum. Behind these statistics are individuals and families who need our help. I am using the statistics as a call to action. Like doctors, scientists, and hourly workers who took care of us during the first year of the pandemic, lawyers must also get on the battlefield in our lanes, given our expertise. Accordingly, since I am only licensed to practice law in Illinois and Michigan, this is my attempt to bring a talented group of my professional colleagues in DC to the table to help create a new normal. Now, we cannot provide legal advice in this forum, but we can unveil fundamental information behind the topics reflected behind me. We have so much work to do, and throughout this program, please don't hesitate to list your questions. Now, people need this information. Let's begin so that we can empower you. Let me welcome my panelists, all of whom will be speaking individually and collectively, but let me thank you at the outset for all of the work that you are doing in this area. I will be introducing you by simply calling your name because we have added a Google document so that our guests, everyone in the audience this evening, can actually see your biographies. We have so much information to do until I thought that we might just simplify that process. So let us begin. As reflected behind me, we've got this agenda. So all of these slides for our audience and friends are calibrated to these 3 main topics. So as I move through the slides, our speakers will be addressing those topics. Let's begin with an overview of the eviction process. And Lauren King is going to start the discussion for us. Lauren, please help us get underway.
Everyone. My name is Lauren King. I am an attorney with the DC Bar Pro Bono Center. I help tenants who are facing eviction, and I also mentor pro bono attorneys and oversee some of our clinics. So I wanted to start out by giving you an overview of an eviction case in DC. And I know this slide is a lot, but we're going to take it together and we're going to take it piece by piece. So in order to start an eviction case in DC, a landlord can't just file a case. They have to serve a notice. Before the pandemic, they only had to serve notices in certain types of cases, and the case that most often did not require a notice was non-payment of rent. During the pandemic, they have to file notices in all cases where the person is protected under the Rental Housing Act. So there are a lot of different types of cases protected under the Rental Housing Act, but for your purposes, the most common are going to be non-payment of rent cases and lease violation cases. So before a landlord can file a case, they have to serve a notice, and the notice has to either say, this is the amount of rent you owe. In order to correct this, you need to pay X dollars, or I'm going to file a case. Or it might say, you have a dog in your unit, your lease does not allow dogs, you have 30 days to get rid of the dog, or I'm going to file a case. So let's say in the dog example, the 30 days pass, that's when the landlord can file the complaint and summons. So I'll pause here and say, you see this little sort of like red box there. If the notice has not expired, the landlord cannot start the case. So for example, if the landlord gives a 30-day notice about a dog, they have to wait until the 30 days has elapsed. They can't file on day 25 if the dog is still there. They can't file on day 29. They have to wait until it has elapsed. I'll also pause and say, the best time to seek legal counsel to help you is when you receive the notice, not when you receive the complaint and summons. Of course, at any point in the case, you can seek legal assistance, but the most a lawyer can do for your case is at the point of getting the notice. So I just want to make that point really quickly. So the complaint and summons must be served. And when we'll get to the service box here, you'll see that there's different types of service. So there's actual notice of a hearing, and then there's legal service. The landlord actually has to effectuate legal service, and it doesn't matter if you were aware that the hearing was going to happen. If the landlord didn't properly serve you based on one of the three methods I put in this box, there is no jurisdiction of the court, and then there is a, motion to dismiss that could be filed. Now, of course, it won't just automatically be dismissed necessarily. A motion might have to be made. But if a landlord doesn't actually serve the notice on the tenant themselves personally, and of course this has to be done by someone other than a party to the case, on someone 16 years or older personally, or through posting and mailing, it is not proper service. Those are the only three ways that you can serve a complaint and summons in DC. And posting and mailing actually means affixing the complaint and summons to the door, not sliding it under the door, not putting it into the door jamb. It has to be affixed, and the mailing has to be within a reasonable amount of time. And I believe the rule is 6 days after the posting, or 6 days, I'm sorry, before the initial hearing. So if service is not proper, this is grounds for a motion to dismiss. And like I said, actual notice is not legal notice. So you found the complaint and summons on the ground in the hallway of your apartment building, that's not legal notice. It was not posted on your door. Now, that does not mean that you should not go to your first court date. It just means that there might be an opportunity to dismiss your case for improper service. So let's say service is proper, a motion to dismiss for service is not appropriate, then you're going to go to your initial hearing. Your initial hearing is where a lot happens. So again, like I said previously, if you get a notice from your landlord, calling a lawyer right away is going to be your best bet for the best outcome in your case. So at the initial hearing, this is your first court date where you have the opportunity to ask for a trial, settle your case, or even postpone this hearing to a later date if you need more time to prepare, get a lawyer, etc. So one really important thing in DC is that if you want a jury trial, you must demand a jury trial at your initial hearing in writing. If you continue your case, you must continue it with all rights reserved. These are the magic words. I wish it wasn't this way, that there is this like magical term that you have to state it when you ask for a continuance. But in DC, the rule is you must demand a jury trial at your initial hearing in writing. And if you don't demand it at your initial hearing, you lose the right to demand it down the line. And I want to make a note about consent judgments. So the majority of cases in DC Superior Court Landlord-Tenant Branch are resolved by what's called a consent judgment precipice. These are essentially where the tenant is agreeing to lose. And you might ask yourself, why on earth would someone agree to lose? Well, I'll tell you. Landlord-tenant court can take all day. A lot of people don't have all day to wait around to talk to a lawyer at the Resource Center or settle their case. So a lot of landlords' attorneys will offer a consent judgment. A consent judgment is where the tenant agrees that judgment will be entered, aka they agree they lose. They have no defenses. In exchange, the landlord will ask the court to stay the judgment or put it on pause. In exchange, the tenant will make payments. If the tenant does not make a payment or even is late on one payment, all the landlord has to do to get a writ and evict a tenant is just ask the court to lift the stay. So I always caution people, before you sign a consent judgment, please talk to a lawyer. If you have any defenses, if you sign a consent judgment, you are essentially telling the court, I am agreeing to lose and I have no defenses. So it is critical at this point that if you're offered a consent judgment, and if you're not sure what you have been offered by a landlord, you can go to the, normally in person, you could go upstairs to the Landlord-Tenant Resource Center. But right now, when we're in remote life, you can call the Landlord-Tenant Legal Assistance Network, and you can ask the court for a continuance, all rights reserved, so that you can review your rights. Consent judgments, unfortunately, are how most cases are resolved just because of the nature of landlord-tenant court, where most tenants are unrepresented and a majority of landlords have legal counsel. So if you're ever offered a consent judgment, stop and think before you sign it, because you are agreeing to lose. That brings us to defenses. So there are a lot of different defenses that you might have in any kind of eviction case. You know, in a non-payment of rent case, the most common defense is housing code violations that the landlord knew about or should have known about. A housing code violation can be as simple as an outlet that doesn't work, and it can be as intense as a rodent infestation. So it's super important to know that you have defenses available to you, even if you believe you owe the money that the landlord in a non-payment of rent case is asserting that you owe. You might have defenses that could reduce the amount of money that you owe. So it's so important to talk to a lawyer about defenses. If you want to assert your defenses, a written answer is not required in the landlord-tenant branch, but it's highly encouraged. I mean, I would say, I don't know a single tenant's attorney who doesn't file a written answer on behalf of their tenants. It puts your defenses on the record in writing so that the court is aware that you're asserting defenses and what they are. There are other defenses. So for example, retaliation might be a defense. There are certain protected rights that tenants have, such as the right to report housing code violations, both to the landlord and to DC government agencies. They also have the right to assemble as a group and organize as a tenant organization. So there might be a situation where a landlord files a lease violation case for a really seemingly minor thing, like you had a loud party one time, or you know, someone said that you uttered something under your breath to them and made them feel unsafe. And you might want to, you know, ask yourself, do I think the landlord has a different reason than what they're really saying for why they're suing me? So there's a lot of different defenses, and of course, it's super important to discuss those with an attorney and really develop what defenses you might have. So
let me just say one thing, because we've got some lawyers on who are going to talk a little bit more. So we're going to get some more detail about those defenses. Let's kind of accelerate a little bit, because of course time is moving by very quickly, but this is our foundation, right? So what are the potential outcomes?
Yeah, so it's really important to go quickly into the option for a bench trial or a jury trial, because that will set the tone for the rest of the case. So there are some benefits to asking for a jury trial. The right of discovery is the biggest benefit, and time is the biggest benefit. It can take 6 months to a year for a case to go before a jury, which can get tenants time to apply for emergency rental assistance, establish, what their case, gather evidence. The drawback to a jury trial is that a landlord might ask for what's called a protective order, which is where the tenant's required to pay their rent into the court registry. And if paying your rent on an ongoing basis is a challenge for you, that could be a problem. So possible outcomes: tenant can win their case, landlord can win the case. If the landlord gets a judgment, that gives them the right to obtain a writ and proceed with the eviction. And there's also, of course, the option to settle your case, which you have at any point. And I just want to note really quickly, so we can move on, that in non-payment of rent cases, even if you get a judgment against you, in DC, you have the right to redeem your tenancy or pay to stay. So you can pay what you owe until the moment the marshals are at your door to change the locks, and they have to redeem the tenancy, and the marshals have to go home and not change your locks or perform the eviction.
If you have any questions, please don't hesitate to put them in the chat. We're going to keep moving forward and now take a look at a different, if you will, type of tenancy. Namely, we're going to hear from Gregory Mays, who is the General Counsel for the DC Housing Authority. Mr. Mays, please, welcome.
Thank you, Flores, and good evening, everyone. When we learned about this panel taking place about tenants, evictions, and the evictions rights, we knew we had to be part of it because DCHA, the DC Housing Authority, is the largest landlord in the district. And so that means a lot as far as being a landlord, because we are a direct landlord to families living in our buildings. And we also issue vouchers for families who use at housing of their choice. So tens of thousands of families are affected by DCHA and decisions made by DCHA. So Flores, we're very happy to be able to participate in the panel discussion. And before I introduce my colleague, Deputy General Counsel Andrea Powell, a brief overview of what we do. As I said, DCHA is a landlord. It's a housing authority, but it's also a landlord. But unlike other landlords, DCHA has a mission. And so our mission is a dedication to our families, to low, moderately income, extremely low income family, to provide housing, safe housing for them. And that's our job. That's our job one. That's why we exist. And so we remind our property managers, remind our executives, we remind our staff that DCHA is in the housing business. We're not in the eviction business. And as Andrea will go through some of the different options available to tenants who find themselves as a result of this pandemic or a result of any sort of income variation that takes them down to the extent where they have problems paying their rent. We're flexible to that extent. And so what we want to have happen, if you see a housing authority in court evicting a tenant, you know that everything else has been exhausted. We try to give tenants the right to due process, to grievance hearings, repayment agreements. And so those are kind of things that private landlords simply don't provide. And so we provide them because once again, our job is to make sure that our families are housed in safe, decent housing. Now, DCHA is an independent entity. A lot of people confuse us with the district itself, although from time to time we do get assistance from the district. We are independent from the district. As I said, we're one of the largest landlords in the district, and we administer both public housing, which is housing that we own, and also the Section 8 vouchers. And based on income, it depends on how much subsidy that you receive. And so we're happy to be in this space, Flores.
Well, thank you so much for joining us. Thank you.
And I think that it's good that people are reintroduced to the Housing Authority and know the options that our families have.
Well, thank you so much. And let's move on now to get Andrea involved because, again, we're tracking the information that was in the flyer. And so now we've talked through and we've had an overview, but now let's look at some of the changes, if any, that have taken place during the pandemic. How have you been impacted? Or how have the, shall I say, the tenants been impacted by what you have done? Welcome, Andrea.
Good evening, everyone. We wanted to share with everyone some of the things that DCHA has been doing as a landlord. As Lauren has gone through the eviction process, these are some things that we do all the time and have been paying especially attention to during the pandemic. So the main thing that we want to make sure that everyone continues to know is no evictions are occurring during the pandemic. Various moratoriums are in place. And what we are doing and have done since the beginning is continue to work with our residents, actively working with residents and participants to know that we are here for them. We want, even with being sometimes closed or remote work, we've had opportunities for people to drop off their recertification. So if there's a change, because we realize so many people have been impacted, we want people to send in their documentation by dropping it off, by going to their property manager if they're on a public housing site, to let us know, because once they let us know, we will reduce the amount that they owe. And so that is one of the ways to continue to support both residents in public housing as well as participants in the voucher program. We want to make sure we certainly acknowledge that the moratorium is in place from the CPC through the end of the month, and then the DC is extended through July 25th. And even when that happens, and we'll see, and I think Lauren's going to talk about later how we're going to come out of this thing, no notices can't be served. She talked a lot about case begins with a notice. Well, we hope not to even get to that point. We hope that people are able to work out, come to the property management office or contact the property manager about any issues, any changes, so that we can work things out in advance. But in any event, no notices can be served for at least 60 days after the moratorium. And so we really want to work with residents to make sure that they're in the best possible situation.
Very good. So the moratoria exists across the board, and DC Public Housing is absolutely making sure that all of the people there are safe. Thank you so much for your service. Let's double back to Lauren King again for just a moment, who's going to talk about some of the changes in landlord-tenant court given COVID-19. Thanks again, Lauren.
Hi, everyone. Me again. So I want to talk to you as quickly as I can, because we have so much ground to cover, about the COVID-19 update. So this is current as of me drafting this slide on June 4th, and I believe all of this is still current. It is a moving target, so just be aware of that. But right now, no evictions are allowed until the end of the public health emergency in DC, which is July 25th. And when I say no evictions, I mean actual evictions by the U.S. Marshals. So this is situations where a landlord already had a judgment and a writ, so not new cases. So no new cases can be filed until the public health emergency plus 60 days. That also goes for no notices to vacate for any reason until the public health emergency ends plus 60 days. And an update in COVID-19 emergency legislation, tenants can ask the court to seal old eviction records under this new law. Call LT1 if you want help sealing your eviction records. I oversee that entire project. Tenant payment plans are a huge thing. So under some emergency and temporary legislation, landlords must offer a payment plan if the tenant fell behind due to the pandemic, and the plan must be 12 even payments over 12 months. And offering the plan is required before filing a non-payment of rent case where the tenant fell behind due to COVID-19.
Very good. So what we've tried to do was to provide the information from the public housing perspective and from the private perspective. So let's keep going. We've got a lot more information to discuss. If you look at the flyer that we distributed, the next major section we captioned as prevention and help. And we have multiple sections under here, starting with lawyers on the front line. Professor Schneider, are you available? Val
Yes,
Schneider? All
Can you see
right.
me?
Very good. Welcome.
Thank
Valerie?
you. Thanks for hosting this forum. I appreciate it. I'm Valerie Schneider. I work at Howard University School of Law, where I direct the Fair Housing Clinic. I work with law students who represent tenants in legal disputes with their landlords. And we do housing discrimination work, housing code violation work, some eviction defense work, and all sorts of we try to help tenants with all sorts of legal problems they have related to their housing.
Thank you for all that you do.
Thank you. Working at Howard is the honor of a lifetime. So all tenants in DC have the right to live in units that are in compliance with the housing code. It doesn't matter if you have not paid your rent, if you're violating your lease in some other way, you still have a right to live in clean, safe, habitable housing that is in compliance with the housing code. It can be challenging to figure out, well, what does the housing code cover? And so I'll talk really briefly and very quickly about some common housing code violations and some ways you can enforce your rights. You can move on to the next slide. So during, you might be thinking, well, if there's an eviction moratorium, why are we talking about housing code violations? And that's for a number of reasons. One is that while evictions are not moving forward, housing code violation cases are moving forward. So you can bring a lawsuit against your landlord for violating the housing code. Those cases are all proceeding currently online. The other thing is that during the eviction moratorium and during COVID, the housing stock in DC has deteriorated for a number of different reasons. One is that some landlords unable to go to court to evict their tenants legally are constructively evicting by letting the conditions in the units degrade, hoping that tenants will eventually flee. And then also some landlords are having cash flow problems related to the moratorium and related to COVID, and may not have the resources to repair the housing. And so, as I said before, notwithstanding COVID, notwithstanding the eviction moratorium, every tenant in DC has a right to live in safe and habitable housing. And there's a lot tenants can do to empower themselves. So first, if you're a tenant and you've got housing code violations in your house, you should make and document your maintenance requests. So keep a log of every maintenance request you get, communicate in writing or email, keep a log of all the responses, take pictures, etc. You can also call DCRA, which is the Department of Regulatory Affairs, and request an inspection. So you can get someone from the city to come to your apartment. They do both virtual and in-person inspections right now. And finally, if you're unable to resolve the issue by just communicating with your landlord, you can sue your landlord in a special part of Superior Court called the Housing Conditions Calendar that meets every Tuesday. And that's a place where even without an attorney, you have an opportunity to enforce your rights and have repairs made to your unit. Move to that slide. So you can find the housing code in the DC municipal regulations and the property maintenance code. And it covers things both inside your unit. So think about things like leaks, whether your appliances work, heat, cooling, whether your windows open and close, whether your locks work, all of those things inside your apartment. And it also includes things outside your apartment. Are the hallways lit sufficiently? Are the paths lit sufficiently? Is there proper garbage and trash storage and removal? And then the other thing that the housing code says very clearly is that a landlord may not retaliate against you for asserting your rights under the housing code. So if you call your landlord and make a maintenance request or 2 maintenance requests or 3 maintenance requests, and your landlord says to you, that's it, I'm tired of this, I'm tired of hearing from you, I'm not, I'm gonna move to evict you now. That's retaliation. So even if you have done that, like even if you haven't paid rent, even if you're in violation of your lease, if you can show that the reason your landlord is evicting you is because you raised your rights or tried to enforce your rights under the housing code, that's prohibited by the housing code itself. So a lot of tenants, a lot of my clients really fear that, well, if I try to assert my rights, my landlord's going to come after me for every single little violation and try to evict me. They're prohibited from doing that under the housing code. So I encourage all of you, and I say this to all of our tenants, like I said before, document, and don't give up. The thing that is important to know about the housing code is that it really empowers tenants to take action. And I know that that many of my clients are dissuaded. They make a maintenance request after maintenance request after maintenance request with nothing being done. But I encourage you not to not give up. And I believe that we're going to circulate some resources of attorneys you can call if you're having trouble effectuating change yourself. The other thing to know is that, as I mentioned before, we represent people in housing conditions court, but it is not necessary that you have an attorney. It's possible for you to file a complaint yourself. And I put the links to some resources in this slide, but if you just Google DC Housing Conditions Court, there's a really good explanation that the court itself put up with a link to the complaint. And the complaint form is very simple. It's essentially a checklist. You check, here are the problems in my unit. If you are low or no income, you may also file something called an IFP, in which case, if that's accepted by the court, then you don't have to pay the $15 filing fee, and the court will take over some of the administrative issues related to filing a complaint. So the court will take over service of process, which can make the case run a little bit more smoothly. And again, this is something that you can do without an attorney, but there are plenty of resources, legal services organizations, including the Howard Clinic, that will help you if you feel that you need an attorney.
Thank you so much. So you want to provide us just with a brief overview of
Sorry, I thought you were
goes
trying
on?
to cut me off.
Okay.
Sorry.
No, no, we
And if
need
anyone-
you. We need you, Valerie. We need you.
What you really need is, the students, my law students at Howard are really, they're the people who are in court effectuating change. You don't need me, you need them. I can just tell you very, very briefly, and feel free to put questions in the chat or reach out. I'm very Googleable at Howard, and I'm responsive to email, so feel free to reach out to me. At an initial hearing, I talked about how it's relatively easy to file the complaint, and then you get to appear in front of a judge. And again, you can do this on your own. Currently, these cases are proceeding online, so that just make sure that you understand. They'll send you instructions for how to get online. If you need assistance, call the clerk or email the clerk back, and they will help you get online. And it's really an informal process. You don't have to know the rules of evidence. You don't have to have gone to law school. I have to say, some of my clients, I feel like, have gone to law school because they really understand the process quite well. All you have to do is make sure you're there and you have an opportunity to tell the judge, here's what's going on in my unit. Here's what the violations are. And some things the judge are going to care about is access. So talking about, be really specific about, I made these requests 10 times and I'm always available, or I'm available 9 to 5, or I'm available 3 days a week to let the landlord in. But despite my availability for access, the landlord's not making the repairs. And the other thing you should do at the hearing is request an inspection. And again, they'll send an inspector out from DCRA, either in person or remotely, depending on your preferences, to take a look at the unit. And honestly, I've been doing this for a long time, but every time I have an inspector out there with me, they notice housing code violations that I might not have noticed. So you might go in with 3 or 4 or 5 things that you're thinking are really the most important thing, and the inspector says, but there's a problem with the electric that was putting you in danger for a fire that you might not have known about. So getting that inspection is really important. And then finally, and I think a previous speaker mentioned this as well, the housing code is really important because when the eviction moratorium is lifted, because the condition of units have degraded over the last year and a half, housing code violations are going to be an important defense in eviction cases, to say, I may be behind on my rent, but one of the reasons I'm behind on my rent is that I shouldn't have to pay the full amount of rent when 2/3 of the unit are uninhabitable because of a leak or mold or something like that. And so it can be really important not just to assert your rights as a plaintiff, but if you're a defendant in in an eviction suit. And again, I'm happy to answer any questions. Just look me up or put them in the chat. Anything I can do to help tenants, I'm happy to do. Thank you for convening this forum.
Well, thank you for all that you do, and we salute the students, because those of us who are professors are there so we can pass the baton back to them. And so we're also celebrating not only what nonprofits and these lawyers on the panel are doing, but also our law students who are very busy, as we know. So thank you so much. We now want to turn to Brooke Hill. And before I do that, I want to remind everyone in the audience that we have attached a Google Doc that has everyone's biography on it. And we just thought, in the interest of time, instead of spending more time talking about each other, we would simply send our information so that you can read it at your leisure, because we've got to get this information out. So let me turn to Brooke Hill. Greetings, Brooke. Welcome.
Good evening. Thank you. My name is Brooke Hill, and I'm an attorney in the Fair Housing Project at the Washington Lawyers Committee for Civil Rights and Urban Affairs. What the work that we do is fair housing work. So we help people with discrimination claims of a wide variety of different sorts. Do I have control over these slides? I'm sorry. Okay. So, unlawful discrimination is discrimination that's based on certain what are called protected traits. So nationally and in DC, there are 7 protected traits, and you're probably familiar with most of them. So race, religion, color, national origin, sex, familial status, and disability. But DC also protects a number of traits beyond what are protected nationally. And those include marital status, age, source of income, personal appearance, sexual orientation, gender identity, political affiliation, matriculation status, place of residence or business, and status as a victim of an intrafamily offense. So, some of the categories that we see a lot are source of income and also sexual orientation or gender identity. Did we skip a couple slides?
Are you there, Brooke?
I'm here. Okay, well, it looks like we accidentally skipped a couple of slides. So I will just, I guess, use my own slide deck. But, there's, discrimination that can come up in a variety of different ways. So, the most obvious is like during a housing search. And if during a housing search you feel like you've been discriminated against, you can, there's a few questions that you could ask to sort of see if what you're experiencing it might be unlawful discrimination that you could take action based on. So the first question that you would want to ask yourself is, do you have a protected trait? Were you qualified for the unit that you were interested in? Did you apply, and were you denied, essentially? And if the answer is yes to those questions, I think that you would want to think about speaking to an attorney. We run into this a lot of times with voucher holders. They don't necessarily tell you outright that we don't accept vouchers, although sometimes they are silly enough to. But they often will try to fog the situation. So if the answers to these questions are yes, and you were trying to use a voucher, you might have experienced unlawful discrimination. Another area are differing terms and conditions, and this would be when you're actually in housing. So, whether you're experiencing discrimination at the hands of your present landlord. And some of these would be, are there special rules for children? Are there special rules for tenants in affordable units or for those who have vouchers? Is management or maintenance more responsive to white, and or English speaking residents? These are sort of the type of differing terms and conditions that people have been complained of, or have complained of to us, and these also could be reason to seek an attorney because unlawful discrimination could be happening. And then another form of discrimination that folks unfortunately experience while they're in housing at the hands of either their current neighbors or the current landlord is a hostile housing environment. And that works more or less like a hostile work environment, which many people are aware of or familiar with, usually in a sexual harassment type of context. And in the housing context, it's the same. Regardless of whether the protected trait is sex, there could be sexual harassment in housing. It could also be based on familial status, the fact that you have children, or your race. And sort of the things to look at is, is the conduct that you're experiencing unwelcome? Is it severe and or frequent? So it could either be, relatively minor, but all the time, inappropriate, mildly inappropriate comments, or it might be something that only happened once, but is much more severe, like touching. Interferes, and then the third thing is that it would interfere with the enjoyment of the home, and because of a protected trait. Again, unfortunately, we've seen folks experiencing hostile housing environments because of sex, but also because of race and familial status are, I think, the most, and national origin. So in any of those, it's the same as, sexual harassment, hostile housing environment at work. Even if it's your neighbors, if you put the landlord on notice, they have the same responsibility that your boss would have if you were experiencing, sexual harassment at work from a colleague. So sort of the next thing that I wanted to talk about tonight is the tenant right to organize. And, with everything that's happening with the pandemic, folks, losing their employment. Also in some buildings, maintenance has suffered during the pandemic. So people have been trying to organize and sort of, push back and get repairs and, talk collectively to the landlord about rent forgiveness programs and things like that. And whenever that happens, people sometimes encounter resistance from the landlord. And in DC, you have there's a statute, a law that says that as a tenant, you have a right to organize. And that means that you have a right to canvass. You have the right to post and pass out literature and meeting notices. You can invite outside organizers from nonprofits to assist. You can meet in common spaces without management participation or attendance. And landlords are prohibited from interfering or retaliating. So, and that's an actionable right. So you can raise it as a defense, or really any of the things that I've just talked about are actionable rights. So, like housing conditions, they can be raised as a defense in an eviction proceeding. But you can also sue your landlord for violating the right to organize, or for violating your other civil rights, separate from an eviction proceeding, whether or not you're in an eviction proceeding. And then, another big part of our practice at the Washington Lawyers Committee, and I think really any fair housing practice, has to do with disability. And so I wanted to just spend a couple of minutes, talking about how you can either request reasonable accommodations or modifications to help with ability challenges. So the first thing is a reasonable accommodation, and that would be like a change in a rule or a policy to accommodate a disability. So an example might be allowing a support animal despite the fact that a property has a no pets policy. It could also mean moving you from a unit on the third floor to an available unit on the first floor if there is like a mobility issue that might have developed, or maybe it always developed and you just had to live with the third floor unit until a first floor unit became available. But those are examples of reasonable accommodations. So reasonable modifications are when you actually have to physically change a unit. And so a common example are soundless fire alarms. For people who aren't able to hear, they have bright flashing lights that alert you to a fire. Another common modification might be a ramp. If a building has stairs, but it doesn't have a ramp, and because of when it was built in the ADA laws, it's not required to have a ramp, then a modification could be adding a ramp. So in a federally subsidized property, the tenant might not have to pay for the modification, but if it's just like a market rate property, the tenant may have to pay for the modification. They still have to sort of engage with you over the fact that you need the modification, but then at the end of the day, it might be up to you to pay for the soundless fire alarm.
I have a quick question on that, Brooke. If the tenant has to pay outside of a federally subsidized property, what if that substantially adds value to the property itself? Will the landlord be willing to make some adjustments with the rent, or how do people tend to negotiate that?
That's a really tough question to answer. I could do nothing more than speculate. So I think that I just want to stay away from that. I guess, if you're renting a market rate property though, and you've got to, make some sort of investment in the property, I think everything's negotiable, right? And so if you're going to be investing some permanent money into a unit, I mean, you might as well at least lead with some sort of negotiation, perhaps even ask for the landlord to pay for it, because
Right.
that if it's like a common thing that that could make the unit more marketable. But again, that's
Right.
just speculation.
Yeah, well, the law professor in me is coming out because, the owner of that property will always have that improvement, which will add to value. So I just thought I'd mention that and give people perhaps a negotiating strategy. How's that?
Right. And there's absolutely nothing that says, reasonable modifications and reasonable accommodations are really about negotiations. So, I think that's right. Don't sell yourself short. So whenever you're requesting an accommodation or modification, it needs to be done in writing. It has to state what you're requesting and explain, how the accommodation or modification is related to your disability. And then this is just our contact information at the Washington Lawyers Committee. So we do, intakes with folks who feel like they've experienced unlawful discrimination, and you can call the number. It's also possible to just call and speak to us directly in Spanish. There's an extension there. And there's also an online intake form. Thank you.
Florice, there's one thing that Brooke said that regarding vouchers that set off some conversation in the chat. But I think that the way that things are now, everything has been weaponized. People use the word Section 8 as a sort of new racial hate word. If someone's Section 8, then the family is a certain way, it looks a certain way. Then there's no harm in being a voucher family or Section 8. There's nothing to be ashamed of. This country has many people, millions of people that receive subsidies of some kind, whether it be Fannie Mae, Freddie Mac, or GI Bill, or some other sort of help and assistance. And so we want to make sure that people know that, you know, the Housing Authority sees vouchers as an opportunity for families to move into areas that they otherwise could not afford. And so we want to, in that process, we want to make sure the families take full advantage of that and not be ashamed of needing help.
Exactly. And, you know, that's the premise of this, you know, forum. Everybody is entitled to safe and affordable housing.
Yes.
And that's our premise, and that's important for all of us to remember, irrespective of where you live. Thank you so much, Greg. So now I'm going to shift again because, of course, time is never on our side. And we have an opportunity to hear directly from Attorney General Racine. He has prepared a special message for us. So if everyone would pause for a moment, and I think he needs no introduction.
Hello, everyone. DC Attorney General Carl Racine here. Thank you so much for having me today. As many of you know, the Office of Attorney General for the District of Columbia, also known as OAG, protects DC tenants. When a tenant enters into an apartment lease, a landlord also agrees to provide them with livable, safe housing. OAG does everything in our power to ensure that district residents are provided just that. We use the law to protect tenants, hold abusive landlords accountable, and to preserve existing affordable housing. At my office, we've seen it all when it comes to abusive and neglectful landlords: mold, leaks, lack of heat or hot water, lead paint, vermin infestations, fire code violations, lack of basic security measures, and unfortunately, much, much more. We've also seen that this negligent behavior does not apply to landlords alone. We've also taken action against real estate companies and professionals who have illegally discriminated against district residents who use housing vouchers to pay their rent. Fortunately, we've managed to resolve most of these cases by winning court orders that force these building owners to fix the issues that brought us to court. We've also secured millions of dollars in restitution for residents who were forced to live in hazardous and unsafe conditions over the years. By bringing these cases, my office has helped to ensure residents of all income levels, including those who may have limited means to relocate, are safe in their neighborhoods and free from discrimination. Under district law, tenants are also protected from landlords with shady business practices, such as improperly withholding security deposits, collecting illegal late fees or attorney's fees, harassing tenants to pay their rent, charging incorrect or improper rent increases, charging illegal utility fees, and engaging in other potentially deceptive practices. When tenants witness this type of illegal behavior, they can submit complaints to our Consumer Protection Hotline at 202-442-9828. Tenants will be assigned to a mediator who will contact the landlord and try as best we can to resolve the issue without having to file a lawsuit. If a large number of tenants have made the same complaint, in some cases, an investigation will be initiated and an action might be brought in court to stop the practice and to seek restitution for injured consumers. It's no secret that many tenants throughout DC have faced challenges over the past year due to the pandemic. Many residents have struggled to pay rent and other bills due to economic loss and uncertainty. To help understand what your rights are as a tenant during the public health emergency and what your rights are as a tenant after the public health emergency ends, visit oag.dc.gov. During the past year, OAG received nearly 500 complaints from tenants, 158 that involved COVID-related issues, such as illegal evictions, rent increases, or late fees. In one case, a landlord sent out illegal notices to vacate at least 23 tenants. The notices were illegal because notices to vacate are barred during the pandemic, and because many of the tenants spoke Spanish and the notices were only in English, the notices did not comply with district law. Because of our engagement, the landlord entered an agreement with our office to rescind those notices. It also had to pay the District of Columbia a fine of $17,250. But OAG does not do all of this work alone. We partner with other district agencies, such as the Department of Consumer and Regulatory Affairs, also known as DCRA, tenant organizers, legal services organizations, and our partner, the Office of the Tenant Advocate, to protect tenants and provide safe and affordable housing in the district. DCRA enforces district laws that require landlords to maintain apartments in a safe and habitable condition. The Office of the Tenant Advocate helps tenants resolve individual disputes with their landlords, counsels tenants about their rights and responsibilities, and provides legal and technical assistance for further action, such as filing tenant petitions or complaints regarding housing conditions. I'm going to leave you now, but I know that you're in excellent hands with our Assistant Attorney General, Olivia Georgian, who will walk you through OAG's work and resources that are available to you. Thank you.
We are now ready to resume, and having heard from Attorney General Racine, we'll continue our discussion with Olivia. Olivia, thank you so much.
Hi, everyone. Thank you so much for having me. And AG Racine is going to be a tough act to follow, but I'm just here today to essentially give an overview of OAG's housing work. Unlike other organizations that are presenting today, OAG doesn't represent individuals or even a group of individuals. We really represent the district and the district's residents, including tenants. And so that's one key difference to remember about us. That being said, we work to hold bad actors accountable and make sure that district laws are not being violated. And so I listed here the three main enforcement actions that OAG takes in its housing work. So one thing that we do is we work on Tenant Receivership Act cases. And what does that mean? It's essentially when a residential apartment building is not being maintained. There may be leaks, holes, mold issues, lead paint issues that really impact residents' ability to enjoy their apartments and to live in safe and habitable housing. In those cases, we essentially ask the court to appoint a third-party receiver to manage the building. And in some cases, if the current landlord is not able to make the repairs to bring the building up to compliance, then we essentially remove the building from that landlord. That's the first type. The second type of case that we usually bring are cases under the Drug, Firearm, and Prostitution Nuisance Act. And essentially that's when either a commercial property or residential property is facilitating nuisance activities specifically tied to the presence of drugs or firearms, sometimes prostitution, but that's not the one we see most frequently. And we work with the landlord to implement security upgrades to that property. And I can give an example later on. And then the last bucket of cases that we handle are enforcement of COVID-19 housing protections. So for example, you heard AG Racine mention a case where a landlord illegally issued notices to vacate to tenants when they were not supposed to be doing that. And we were able to intervene to have those notices rescinded so that tenants' rights were not being violated. That's just one instance that we've intervened in, and we have issued a lot of cease and desist letters to landlords for them to stop those practices. I'm going to be delving a little bit into more detail for each of these types of cases, but I'm going to try and be mindful of time. And so I may skip some of the slides depending on what our time is looking like. So the Tenant Receivership Act applies essentially when there are significant risks to the health, safety, and security of tenants. And the slide elaborates on this a little bit, but there's either the DC Department of Consumer and Regulatory Affairs has already inspected units in that building and has issued notices of violation, or simply tenants have documented repair issues in the building. And so in either of these cases, OAG essentially is able to intervene and file a complaint under this act. It's especially important to know that we do try very hard to preserve housing subsidies. So if repair issues are jeopardizing a federal subsidy from HUD, then it's especially critical that we be able to preserve those subsidies so that tenants don't have to pay market rent. If we can go to the next slide. Thank you so much, Flores. So in those cases, we ask the court to appoint a third-party receiver who essentially takes over the management of the property. And so they're the entity that collects rents, that makes repairs. That's the most critical part. And the owner can propose a plan to make repairs before a third-party receiver is appointed. But if the owner is not able to comply with that plan, then we ask the court to move on the process and appoint a third-party receiver. If we go to the next slide. There are some challenges with our Tenant Receivership Act cases. They essentially take time. We investigate and we collect evidence, and that is not a speedy process all the time, as much as we try to move along things as quickly as possible. Court takes time, litigation takes time. Sometimes the courts allow the owner, give the owners a chance to abate the repair issues at the property. It's also sometimes difficult to appoint a third-party receiver and to find a good one who will make the repairs and use the rent money appropriately. And so I think it's especially critical to reach out to legal service providers, even if OAG is investigating, just because if you want to make sure that your own individual rights are not being violated, or that you want to try to bring about repairs in a speedier way, I think having individual representation is especially critical. And we often do work with legal service providers and tenant organizers to bring these cases. And so it's really a team effort. If we can go to the next slide. And I don't want to repeat myself here, but we really do intervene in cases where multiple units in the building are affected, and there's really a pattern and practice of neglect. And here on the slide, it does mention some of the remedies that Professor Schneider mentioned earlier in her presentation, and Lauren King actually too. And I included some examples of some of the receivership cases that OAG has brought in the past. Forest Ridge and the Vistas is one of our most recent cases. And in that case, as AG Racine mentioned, we were even able, not only were repairs made, but we were able to get restitution to tenants, because when tenants pay rent, they have the expectation that they will receive habitable housing in exchange. And when that doesn't happen, we do ask for the landlord to provide some of that money back to the tenants as restitution. And the second big case that we were able to bring was against Thomas Stevenson. And similarly, we were able to get restitution for tenants in that property as well. And so I just listed those two as some of the most recent examples of cases we brought under the Tenant Receivership Act. Moving on to the Nuisance Act. I think the word nuisance has a broader meaning in everyday language. The DC Nuisance Act is very narrow. It really focuses on properties that facilitate the storage or use of firearm or drugs, and prostitution, although like I said, that's the one we see least often. And we have to show that the activity is having an adverse impact on the community. we get a lot of complaints from DC residents primarily regarding, for example, commercial properties that impact the ability of these tenants, of these residents to access services. So for instance, if a gas station is enabling drug activity and tenants are too, I'm sorry, I keep saying tenants, residents are too scared to purchase their gas in those gas stations, for example, that's one instance where we would intervene. We send a letter to the landlord, to the property owner as a first step, and then if the owner does not respond to us or implement some security upgrades, and we pursue those cases in court. And so that's really the big picture that is important to know. And the third type of cases that we enforce are COVID-19 protections. So as many people on the panel have mentioned, COVID-19 has led to some extra protections to tenants in the district, and some landlords, actually many landlords, unfortunately violate those protections. And so we get a lot of referrals from tenants, from legal service providers and community organizers, and we're able to also intervene. And so we usually, our enforcement can span cease and desist letter, sending a letter to a landlord saying, please stop this practice, all the way to, investigating and filing a case in court. And it can be related to, illegal evictions, but also late fees that are being imposed, because late fees are not supposed to be imposed right now. Illegal rent increases that are not supposed to be taking place during the public health emergency. A month-to-month fees that are really rent increases, but disguised as another fee. And so any violation we do look at, and if it's a pattern in practice, we intervene more strongly. As AG Racine mentioned, we also engage in mediations with housing providers if it's something that we can easily help a tenant with. If owners are amenable or don't want to be brought to court, then they often settle with us and pay a penalty and rescind whatever the illegal action was in the first place. So that's really a basic overview. We also enforce consumer rights when they intersect with housing, but I really wanted to mention the COVID-19 protections. And so I believe that is the end of my
That's the end of your presentation. Well, thank you so much. So,
Thank you.
of course, all of these speakers were behind a very specific section, lawyers on the front line. And of course, I use that terminology because we are in a battle. And these lawyers are addressing these issues every day. So certainly what we do as lawyers isn't as difficult as what our soldiers do. But at the same time, in our lane, these are the lawyers. We tried to provide a selection of lawyers who covered a broad spectrum, just to give you an idea of the work that is happening in DC. And so I just want to personally salute all of you for the great work that you are doing. And we're now going to, as we tiptoe toward the end, we have a long list of resources that we want to share. And I'm going to ask Lauren King very quickly just to explain the LTLAN collaborative. But other than that, we look forward to now hearing from you. So if we have some questions that we need to address, because we're tiptoeing toward the end of our time, I think we could do it for another hour and a half and still not have enough time. But Lauren, if you could just give us some idea here of what this is all about.
Thank you, Flores. So I want to talk to you briefly about the Landlord-Tenant Legal Assistance Network, LT-LAN. This was founded during the pandemic because normally there is a resource center in the courthouse where people can walk in and get services. And we realized we were missing a lot of folks during the pandemic. So the DC Bar Pro Bono Center teamed up with 5 other organizations to start LT-LAN. And LT-LAN is a collaborative project between these organizations that provides free legal information, advice, or representation to tenants and small landlords in DC. So we're one of the only organizations that actually can provide legal information to landlords. So for the purpose of this presentation, we're going to talk briefly about tenants. So people who qualify for LT-LAN services are low income and have a housing issue in DC. And if you're not sure whether you qualify, you absolutely should just call us. And we have the lines are staffed live. And we have English and Spanish speakers on staff, and we also utilize language line if someone speaks another language beyond English or Spanish. So the calls are answered live. Our intake specialists can help you. And tenants who are over income will, at a minimum, get legal information from our Landlord Tenant Resource Center. So what kind of cases can LT Law attorneys assist with? So the most common one, of course, is landlord-tenant cases in DC Superior Court. We also can help with housing conditions. We can help with rent control issues. So that might be tenant petitions, illegal rent increases, or a reduction in services on a property. We can talk to you about the Tenant Opportunity to Purchase Act. We can talk to you about questions about subsidized housing, including source of income discrimination issues or issues with vouchers or subsidies through HUD. We can assist with eviction case record sealing, and we can talk to you about questions about new COVID-19 housing laws.
All right. Well, thank you so much, Lauren, for compiling this information, and again, for all that you're doing in connection with this work. So we have a collection and a long list of, wonderful legal housing service providers. So ultimately, we're going to be releasing this recording, but we will also release the slides because I hope that everyone agrees you have some very detailed information in here that you can use and/or that you can pass on to someone else. And that ultimately is exactly where we are. So before I proceed, since time is of the essence, let me take a moment to see if we have any questions because I do not want us to run out of time. And I think that we've already heard wonderful details from our panelists concerning how to prepare your case. I think we've heard some great information about that. So I'm going to slip past that in the interest of time. I think that with respect to the strategies to avoid eviction, there might be some questions there, but ultimately, please let me know if you have any questions. Otherwise, I have a question for the panel, but let me defer and at the same time thank my research assistant, Evelyn Dalmasy. She has been invaluable. I wouldn't be able to be here without her. She is one of our extremely bright students at the law school. She's been extremely helpful. So please let me know if we have any questions at this time.
Well, Florice, I think we don't want to forget Stay DC as a resource for people.
Yes.
I think we may have touched on it. I think it's in a slide, but it's a district fund that's available for people who are unable to pay their rent. There's an application process.
Yes.
And it involves working with your landlord. And so that's a resource that people may not be aware of that's available.
Very good. Yes, $350 million. It's my understanding that families have to make less than $80,000 and that the mayor was instrumental in providing this. So please, please, if you don't need it, please pass this information on to someone else. But we are going to provide a long list of resources. And I want to thank the panelists again because they were instrumental in helping to pull this material up in addition to the research that we did. But we just have a wonderful collection of work here. So let me just let Lauren come on again for a quick moment if we don't have any questions, and then I have a quick question just to close it out. Wait, maybe we do have a question. Evelyn, do you have a question? I just saw something in the chat, but it happened so quickly I could not see it.
Yes, we have something in the chat from Mr. Rosen. He's saying, it is my understanding DC Council carved out an exception to moratorium for eviction situations where a tenant is posing a danger to other tenants. And his question is, has anyone had experience in dealing with such evictions and whether the court is processing them? Thank you for your question, Mr. Rosen.
Thank you, sir.
I'm happy to field that one if you'd like, Professor.
Thank you.
So yes, there is a public safety exception that was passed by the DC Council. It is an extremely narrow exception where the tenant is posing a present health and safety danger to the community, and the tenant has engaged in criminal activity under DC law. So the law does require a notice in that case. The case can't just be filed without a notice. But the law is very narrow. So this is when people are possessing firearms, for example, on the property, or engaging in criminal acts on the property that are endangering the welfare of other tenants. And we, in the Resource Center, I can only speak for what we've seen. We've gotten maybe a few questions about this and seen, one or two of these filed, but because it is such a narrow exception, there isn't a large volume of these types of cases being filed right now.
Okay, thank you so much, Lauren, and for the question. So as we tiptoe toward the end, of course, this pandemic, I believe, is going to be with us for a minute. But we've had some, shall we say, slight modifications to our rules and requirements. And so I thought that it was appropriate as we sort of close out the meeting to try and anticipate what to expect after the pandemic. And I thought that I would just ask the speakers, and Lauren has been, I guess, attending meetings and was able to give us some insight. Thank you, Lauren.
Yeah, so I don't want to first claim to be an expert on what the DC Council is going to decide to do on how to phase out the moratorium. They are going to meet again on June 15th. And from what we've been hearing, there's going to be a gradual phase out. So it sounds like the DC Council and the mayor don't want to just pull the rug out from under folks. They want to actually phase this out. And a major player here is going to be Stay DC. So basically what we're hearing is that the council is going to require landlords to apply for Stay DC funds before suing tenants for non-payment of rent. And I did want to say, Stay DC had some initial hiccups. A lot of folks had difficulties accessing the website, uploading documents, just that kind of stuff. Please do not be discouraged. There is a lot of money available. And if you have questions, call LT Lawn. We can help walk you through the application. We can get you to someone if you have connectivity issues. Don't give up, be persistent. It has been very frustrating initially with Stay DC, but we want to help as many tenants as possible get access to these resources.
Excellent. Another thing that we wanted to wrap up with is that even though we're talking about tenants this evening, although I must say the goal is to ultimately do this very same thing for homeowners. But tonight we're talking about tenants. But as we look forward beyond the pandemic, I thought that we might go back to Mr. Mays. Greg, what's going on? What might we look at and sort of give people an opportunity to think about beyond this pandemic? Well, what should we think about?
Right. So thank you, Florrie. So as we said in the very beginning, DCHA is much more than a housing authority. It's a landlord, but we also much more than a landlord. We also provide opportunities for our families to be on track to own homes. And so there's a process where the money that they pay in rent goes toward the purchase of a home. And Ms. Powell will be able to further explore that. But we want to make sure that people know this. These are opportunities that somehow get ignored because people don't know. And so we're not interested in just keeping people in our buildings or keeping people as voucher holders. We want to make them homeowners as well. And we have a very large number of success stories for the Family Self-Sufficiency Program. Ms. Powell.
Thank you. We wanted to highlight one of the programs that the Housing Authority runs called the Family Self-Sufficiency Program. Many people are familiar with it in the voucher context, but we've recently added public housing. So you can either be at a household in public housing or in the voucher program. And there's 3 tracks. There's a track of home ownership, there's a track of employment, and there's a track of education. And so through these various tracks, we're looking at various ways where some people may want to go on for school, some people want to purchase a home. And so through these resources with it, which include referrals, counseling, training, we are also looking at how can people choose to further themselves either in the voucher program or recently added in public housing. So we wanted to make sure that everyone knew about that because it's not always known, especially for the public housing aspect. And there are opportunities. We all wish that everyone, make sure that everyone is available, make sure they are aware of these possibilities. So thank you.
Excellent.
Information is available on our website and also our call center. It's 535-1002.
Excellent. And so we're at the end here, and I'm sorely disappointed because I feel like there's so much to say, but at the same time, I think that we've covered a lot of territory. So let me take just another opportunity to thank the speakers, because without you doing the work that you do and gathering the information, this program would not have been possible. Now, at the same time, I have a question to ask because we are witnessing a shift. And in some jurisdictions, they are allowing or have already agreed to provide tenants with appointed counsel. And I'm wondering if there are any signs of that taking place in DC. If we start with the premise that everyone is entitled to safe and affordable housing in our country, is it not the case that we should also perhaps, like some of those jurisdictions, consider providing tenants with counsel? I'm just curious. I'd like to hear from the panelists, knowing what given what you've said and knowing how you feel, I think everyone will agree, but I'm just curious. Is that a possibility? What do you think?
Flores, if I could jump in, I do want to, I would love to see DC pass a universal civil right to counsel. It is happening around the country. I believe Baltimore just did it for eviction cases. So I would absolutely love to see that. To advance something like that in DC, we need the community and we need people to call their council members, call your DNC, tell them this is important to you. But I also want to make a pitch for, I oversee the Pro Bono Center's Housing Right to Counsel project, which basically, because there is not a guarantee of an attorney for civil cases in DC, we, along with Legal Aid Society and several big firms in DC, any case where there is a subsidy in place that is filed in eviction court, we offer the tenant the opportunity to have a free attorney. And the way that we do this is Legal Aid looks at the dockets, they scan for any subsidy cases, and they try to affirmatively reach out to those tenants and offer them this opportunity to have an attorney. This is, Legal Aid is very skilled at this, but it's, always going to be an imperfect process. Someone might fall through the cracks. So I just want to make people who are out there aware that this project exists and that if you have a subsidy, which could mean a voucher, it could mean site-based Section 8, it could mean public housing, any of those, that there is more likely than not a free lawyer out there that could assist you with your eviction defense case. So please call LT Lawn if you're ever facing an eviction. There are attorneys available who are ready, able, and willing to assist you with your case for free.
And Florice, I think that should happen. I come from a jurisdiction in Texas that is really conservative. And so if they're able to do that there, where a court-appointed attorney is appointed for the tenant, you can do it here, DC. You can do it here. So I think it takes the advocacy community and the firms to come together and make sure that the tenant has the tenant's due process rights are protected.
That's right, because this is the second forum that I've done. The first one was in Detroit, Michigan, and now here. So I look forward to going to a forum, frankly, where that is already in place. But I think that we're going to have just an incredible volume of cases after this pandemic is over or after the moratoria, plural, get lifted. So I think we're going to have to do things a little differently. But let me pause again to salute what Lauren and her colleagues are doing, but I think we've got to go in that direction. Brooke, what do you think? I mean, how are you feeling about that?
I don't know that I have much to add beyond what Lauren said. I mean, it's definitely something that we would like to see here in DC, and I know that there are attorneys that have been working on that in DC for years. And also just from if you think about it, just to put things in perspective, a lot of folks haven't experienced an eviction, and so sometimes if you haven't experienced it, you don't think about it. But I mean, we give people who are facing incarceration attorneys, if their liberty is going to be taken away, and losing your home. I think if there's something that's short of losing your liberty, but not much short, it's losing your home. I mean, there's not much, there's worse a blow that the courts can deal to you besides literally putting you and your children out in the cold. I mean, when it comes to incarceration, most of the time it's just you that gets incarcerated, right? But when it comes to eviction, it's your whole family that gets put out, and that's a very serious consequence,
It's stressful.
and it shouldn't be taken lightly.
It's stressful to a family. It causes stress, a great deal of anxiety, and following your logic, if it's a right of due process, why shouldn't they get counsel? Why shouldn't tenants get
Exactly. Yeah.
That's right. And that's why I started our discussion by laundry listing all of the impact, all the impact. It's incredible. And we take it for granted that people will recover. But
Right.
of course, this pandemic has reminded us that people are vulnerable, and we're even more vulnerable. And it's been 100 years since we were this vulnerable, but I think it's something that we might want to seriously consider. Let me invite another panelist to join. I don't know if Olivia or Valerie or Andrea.
I'll echo what others have said about the right to counsel, but also, I think one of the things we really need in DC and across the country is clean, habitable, and affordable housing, and more of it. Most eviction cases in DC are non-payment of rent cases, and it's incredibly important to have an attorney for those cases. But really, what's even more important is to have affordable, habitable housing for tenants, because that's important to the entire ecosystem of our city. And the impact of evictions is not just to the family, like Brooke described, which is clearly the primary and most important impact, but it's to communities and to our whole society. It's to schools. It's to the fabric of our neighborhoods. It's to it's causing gentrification and exclusion, and those impacts go beyond just those individual families. And so, I agree and echo what everyone's saying about right to counsel. And I think alongside that, we need advocacy for more affordable housing and an affordable housing stock that is habitable for our families.
Well, very good. Well, does anyone have any closing thoughts? I simply wanted to raise that because it seemed to me that underlying what you're doing, and trying to bring as many lawyers as we can to this battlefield, if you will, is ultimately going to be very difficult. But if we could put that into the equation, it might facilitate getting that done. And so I just want to pause at this point and thank all of you again on behalf of the Housing Gap podcast and our tremendous panelists. Let me thank everyone for coming to this forum. Today, we have tried to make you generally, and tenants in particular, our first priority. I mentioned some of the statistics. There are many more, but I get tired of listening to the statistics because I want to act. And injustice anywhere, as we know, is injustice everywhere. And Maya Angelou, one of my favorites, said, if you don't like something, change it. And that's what we are attempting to do as lawyers for those of us who are involved at any level. We're trying to make sure that we're part of the change, that we help tenants in particular to work strategically as they anticipate what they are going through and their changes, particularly during this awful pandemic. So let me just conclude by thanking my panel, my terrific panel again. Each one of you has made a tremendous contribution to this event, and I'm hoping that we'll be part of a new normal, that nationally we will see these events taking place. I know that I'm certainly going to try and do it through the Housing Gap podcast. Thank you all so much from the bottom of my heart.
Thank you, Flores.
Thank you. Everyone, have a good evening.
Thank you.
And we'll
Thank
see you soon.
Thank you.
Thank you.